Welcome to Planetary Choices, a podcast produced by Center for New Critical Politics and Governance at Aarhus University. With this podcast, we invite you into our research lab, where we explore the key questions of today. We bring together scholars, policymakers, and activists who are engaged in sustainable planetary stewardship. Thank you for joining us.
Hello and welcome to Planetary Choices. In this episode, I'm joined by Katharina Pistor, who is Edwin B. Parker Professor of Comparative Law at Columbia Law School, where she joined in 2001. She's held teaching positions all over the nice places in the world in Harvard Law School, Harvard Kennedy School, the Max Planck Institute for Foreign and International Law in Hamburg. She's been visiting professor at Harvard Law School, New York University School of Law, and so on, including London School of Economics as well, and Oxford and Tel Aviv. Katharina, you are also an elected member of the Berlin-Brandenburg Academy of Science and Humanities. You're a member of the European Academy of Science, and since recently, a member of the Club of Rome. You joined there in 2024. You received, together with Martin Hedwig, the Max Planck Research Award on International Financial Regulation. And recently, I don't know when this started, but you've been co-directing for a couple of years now the Hewlett Foundation-funded Columbia Center for Political Economy, together with Ira Kretz-Nelson and Suresh Naidu. Now, all of this is just water on my mills for having you here to explain to us what the hell is going on with global governance in relation to law and where we are in connecting legal questions with questions of the economy and the future. In that direction, you're also working on a fascinating new project that you call Coded Power, together with Kopje Georg, who I believe is in Frankfurt these days.
Frankfurt Finance.
Mm-hmm. Frankfurt Finance, yes. So all of this to just say, first of all, welcome. Thank you for joining us here.
Thank you so much for having me. It's really a pleasure to be here.
That's wonderful. Let's dig in. Now, Katharina, you've been given us also two major books which you wrote yourself. You're not just in all of these panels and institutions that are so doing this great work. Check out the Columbia Center. It's really inspiring what is happening there. But also read Katharina's books. The Code of Capital has been, I believe, for me at least, it's been a major read and really inspiring, where you dealt with the role of private law, private debt, business organizations, and how they interact with the shaping of capitalism and a global capitalist order, and actually help may be the wrong word, but we're co-conspirators in really installing an inequality, a structural inequality, which I guess is a theme throughout your work. Now and then recently you wrote The Law of Capitalism and How to Transform It, where you describe again an economic system that is deeply entrenched in an economic regime. And maybe as the last thing from me, as a student of neoliberalism, we always read about economic constitutionalism, having the idea that, yes, the economy is connected to the law, but more on a constitutional, maybe public law level. But you make a point that there's a deep combination between private law and capitalism and globalization. Could you start somewhere, to pick that up somewhere and explain this to the listeners?
Yeah, let me maybe start by explaining the difference between public and private law, because I'm not sure people are always that familiar with it. And there's also a debate in the literature whether the distinction is still as relevant as it might have been. So when we talk about public law, we think about the Constitution, as you suggested. We're thinking about regulation. We might also be thinking about criminal law. So everything that the state does in terms of trying to direct its citizens to do certain things or not to do certain things. The Constitution, of course, also empowers, gives us certain rights and creates checks and balances, but it's basically the governance structure of society that is a top-down legal order. That's public law. Simply said, my public lawyers might want to refine this, but private law is how people organize their social and economic relations with one another. So if you look into the Code Civil in France or the BGB, the Civil Code in Germany, you will find basically default rules, mostly default rules that allow people to write their own contracts, decide how they use their property rights, organize their family affairs and inheritance. These are the core areas of private law. They are legal because we also have developed legal institutions to organize these things so that we can make legal claims and enforce them in a court of law. And what I'm arguing in the Code of Capital in particular is that these institutions of private law, to which belong contract, property, also the law of business organizations, bankruptcy, and property rights is also part of that, is collateral law, or how you can secure assets to make to make the creditor more secure. These areas of the law are part of the private law, and what makes them so interesting is that on the one hand, you can enforce them in a court of law. On the other hand, you can use them much more flexibly than you can use public law. You can use them and create your own transactions. You can use them and create your own business organizations and write their own charters. So you have a lot of flexibility and a lot of control over how you want to use private law.
Yes. Well, I understood that, I think. That's great. Now, when you're a naive liberal or a naive believer in, let's say, social contract theory, then there's a certain idea that by becoming a legal person, you engage in contracts, you have a social contract, and there's equality before the law, basically, so that the society that is constructed through the social contract is based on an equality before the law. But you somehow say that, well, that may be in theory the case, but really what is happening is that private lawyers are pushing that, and there's a structural inequality as an outcome.
Yes, I mean, it's equality before the law is formal equality before the law. We're not looking at how many resources you have to actually use the courts, hire an attorney to defend your rights. We're only saying that in principle, everybody can use the law in a certain way and has, formally speaking, the same rights. And that principle we can uphold. But of course, you can, if you have different resources, you have different ways of using the law. You can hire the better lawyers. You can start thinking about how you can actually use these rules of the game, as they're sometimes called, and restructure the game in a way that benefits your own interests and your own purposes. And that's really the major difference that I describe. Once you understand that the rules of the game are so critical for creating wealth and inequality as a side effect, of course, then it's really about these rules. The game is not only constrained by rules, as many economists would say. Douglas North famously basically said, institutions are the rules of the game. And then we all play within these rules, and then whoever is better wins. And that's fine, because if you're better, you can win. What I'm arguing, actually, within the legal system that we have created in private law, the players can change the rules of the game as the game is in motion. And that makes a difference. So which team can make these differences? Which players can, get away with foul? Not only get away with foul, but actually then institutionalize the foul as a new aspect of the law that they have now created.
Okay, I get it. I think I get it. Could I just repeat this?
Yes.
So there's what I meant with naive imagination, or maybe simplified imagination. So if economic constitutionalism is written to create some kind of framework within which market agency takes place, and that's all then fair game, and we all act according to the same rules. And when we do a sprint contest to each other, we don't make the other person trip over something. But you would say that's not true, or that may be in theory true again. But when I want to make this person trip, and I am one of the keeper of the codes, or I have that influence, I can reinscribe that as part of the frame.
Exactly.
Okay.
That's exactly right. So because the private law is malleable and has many advantages, right? Because we can reorganize our private relations in many different ways. We can take advantage of new technologies. We can respond to changes in our environment. So there's lots to be said for it. But at the same time, while we are giving people the opportunities to do so, we're still upholding the principle that everybody is equal before the law. So you could do this too. You might need $25 million to make it worth your while to go to an attorney to hide your assets in the Cayman Islands to avoid taxes, right? But we don't look at that. In principle, anybody can do this, and you can create sort of legal forms that allow you to separate certain assets from your personal assets and let them grow in a way that the tax authorities can't touch, or your creditors can't touch. There are lots of ways in which you can use the law in this way, but you also need resources to do so. And under the mantle of formal equality, we're allowing a lot of inequality to be created by strategically using the legal system to create wealth.
Could you flesh that out? I wonder, could you maybe give an example? You mentioned the Cayman Islands and assets, and that's already a hint, I guess, of what we could look at. So if we could illustrate that process, and then that would be very important, I think. And secondly, I wonder how large is the game? So do we play it on a regional, a national, global level? Is it a transnational game? Could you dive into that as well?
Yeah, in the book, in the Code of Capital, I give various examples. Let me start with one which might be most intuitive, which is intellectual property rights.
Yeah.
So the interesting thing about intellectual property rights is that you have a patent only once the patent is registered. This is where I think it should click that these rights are bestowed on you by a legal system, by the patent officer if you want, but in accordance with the legal systems. They don't come from nature. I make the same argument also about land, but because land seems to be so physical and so real, the fact that also you require property rights to be able to sell the land is a bit harder to understand. So think about intellectual property rights, a patent. If you have a patent over a drug, you can reap the benefits from the revenue that you're making for a certain period of time that is stipulated in the patent law, 15 years, 20 years. So you have the exclusive rights to use the patent, and anybody else who uses it can be stopped. You can have cease and desist orders to say you can't use my patent, or you have to get a license from me, you have to pay me to use this particular innovation. Here's the story. Angelina Jolie, the famous actress, she wrote an op-ed in 2013 in the New York Times disclosing that she had just had a double mastectomy because she was the carrier of a certain gene that can produce a very aggressive form of breast cancer. Once you have it, you're almost likely to die. And her mother had it. And she had herself tested and found out that she had this gene and that and therefore decided to have the mastectomy. She also mentioned in this op-ed that there was a lawsuit pending at the Supreme Court in the United States because there was a patent created over the sequence of the gene that you need to be able to identify who's the carrier of the gene, and then decide whether you want to have treatment or preventive measures of the kind that she took. And what had happened is that years before, about 15 years earlier at least, there had been a race between a private company in Utah and the National Institute of Health in the United States, or a consortium of publicly funded research groups, about finding the sequence to the patent in order to be able to diagnose patients and then do something about this. It happened that the private company was first, and then it went to the patent office in the United States and got it patented. Now, that already was, to put it mildly, this was kind of an aggressive move, because in principle, we've always said that things that belong to nature, that are part of our environment, and of course the genetic code should be part of that, cannot be patented, they cannot be appropriated. But the US patent law had long allowed people to patent something if there's some human manipulation ingenuity built into this. And so they claimed that they had sort of done something to this in order to find the sequence, and so they should have a patent either way. So they had the patent created, and they charged every woman who wanted to have a test whether they were a carrier of this gene about $3,000. And they sent cease and desist orders to doctors around the country and saying, you can no longer use your self-made kit to find the patent, because many doctors had tried to do something similar. And so they prevented them from doing this, and so made it much more expensive for most women to have the kind of test. In 2013, finally, the Supreme Court struck down the patent because it said, actually, this is part of nature. It shouldn't have been patented. Only a small sliver actually involved human participation, and therefore an innovation that is patentable in principle. But because the company had already created a huge database on the basis of all the tests that they had done and nobody else was able to do, that they now had a monopoly over the data. And the monopoly over the data, they protected again with legal means, trade secrecy law in principle, and said, we will not share anymore. At some point they said, we won't share these data anymore, and you cannot touch them. So that's what I mean. You're using the legal system, the patent law, trade secrecy law, property law generally, if you want, to create monopoly rights and prevent others from using things that are essential for their well-being, that in the past we would have never allowed to be patented. But lawyers had before pushed the envelope and basically said, well, if there's just a bit of human ingenuity, we should patent it, because otherwise people will no longer innovate, etc., etc. So this is by way of an example.
It's a very striking example, which makes me think of the monopoly, the case of having monopolies, which used to be much more contested.
Yes, of course. I mean, and we're struggling with this, of course, with big tech, etc. How to enforce against sort of how to enforce competition law more generally. Yeah. Let me maybe also jump to your second question. Yes, how big is it? So I think these things can happen at the local level, and they also happen at the global level. The important thing about private law is domestic law. In some jurisdictions in the United States, it's even below the federal system, it's state law. So in the United States, the state of New York, the state of Delaware, the state of Kentucky, they all have their own property law, contract law, tort law, etc. What this allows is that you can pick and choose from different legal systems, the one that gives you the greatest possibilities to do stuff. And because the United States is still a single country and has a provision in the Constitution that says we want to have a unified, or not a unified market, but an integrated market, one state cannot deny the enforcement of the law of another state. So that gives you a lot of legal arbitrage opportunities to find the law that you like. And that's already, in the United States, just to give an example, most big corporations are incorporated in one relatively small state, the state of Delaware.
Yes.
Delaware. What else was there in Delaware when they started to basically become the leader in incorporation? Nothing. It was a small agricultural state. There were no big industries, but also no labor unions. So there was no political contestation over the contents of corporate law. So they positioned themselves as a state that offered the corporate law that management would like, because management makes the decision where to incorporate. And now these corporations are Delaware corporations, but they can do business in Montana and California. They can also do business in Germany and elsewhere, because we have also over time allowed principles to seep into our legal systems that say, if a corporation is incorporated legally in any jurisdiction, we also recognize it as a corporation in our jurisdiction. And once you do that,
where does that go? I mean, is this a global phenomenon, or are these bilateral agreements? Or
it's a mix. It's actually, first of all, again, domestic law. So every country has a set of rules. Every jurisdiction, states in the United States have a set of rules that determine which legal system shall be applied if more than one is in play. So let's say I have a Delaware corporation, it does business in New York, and somebody claims it's not a corporation under New York law. Why should it be recognized as a legal corporation with shareholder limited liability, etc.? Then under US constitutional law, the state of New York cannot say, if you want to be in New York, you have to be a New York constitution. You cannot say that. That's constitutional law. But also New York has a set of rules that says we will basically recognize a company that is incorporated legally in a different jurisdiction in New York. Germany is an interesting case, because in Germany, until not too long ago, the rule was, if you have your seat in Germany, that is your major administration of the company, you must be incorporated in Germany. So, for example, if a German company buys a company from the Netherlands, thereby moves the seat of that company to Germany, the company has to be reincorporated under German law.
okay.
The European Court of Justice has said you cannot do that. You can't have rules like that within the European Union, because you're denying the Netherlands that their corporations will be fully accepted under German law. So there has been a tendency over time to make it easier for people to move from country to country, from jurisdiction to jurisdiction, and take their own law with them, or buy into different law, take laws from different jurisdictions and organize their affairs in that way, because they can get certain benefits. So since many countries have allowed, for example, the free choice of contract law. You're in Denmark, I'm in Germany, we might decide we want to use Swiss law because we don't trust either of our legal systems. We could do this in contract law. Corporations, I mentioned, I can incorporate my company in Luxembourg. Maybe I'm getting some tax benefits, but certainly I'm also getting a corporate law that might be more flexible than the German law with co-determination. We don't like co-determination. We just go to a neighboring jurisdiction and incorporate there. We still do business in Germany. What's wrong with that? So you can basically flout the rules that jurisdictions have established for themselves by picking and choosing from a menu of other jurisdictions what you want to do. You don't have to move physically. You're just sending your paperwork to a different jurisdiction.
That sounds easy. Could you just, you mentioned the word incorporate, which of course means to become a body or to sort of take physical shape, which maybe not everybody understands. I find it a very interesting usage of semantics, that you kind of materialize or become corporeal somewhere. I can become a body in Switzerland. How does that work?
So it has changed over time. The interesting thing is we can all do some business together without incorporation, but that has certain consequences. So if we just start a business for profit, if we default, or if you can't pay the debts of the firm, then the creditors of the firm can go against our personal assets.
Yeah.
And also when we just do this without incorporating, then you can manage the firm and I can manage the firm, and the world around us can rely on the fact that we can both fully represent the firm. But maybe we don't like this. Maybe you're a better manager than I, or vice versa. And so we may want to have a different type of structure. So the corporation is a particular business organization that has certain legal features which are important. You can get the corporate form only today by registration, because the corporate form creates features that have to be created in the law. They do not exist outside the law. It's against one of these things that one just has to accept. Originally, the corporation was used under Roman law already for foundations. You could say the state is a corporation in that sense. It is an incorporated body. The business corporation goes back to the early days of colonialism. The English East Indian Company and also the Dutch East Indian Company are the first big commercial corporations that were created. They were created by royal charter in the case of England, and by charter by the General Estates in the Netherlands. And until the 19th century, early 19th century, late 19th century, it varies by country, corporations required a special act of the legislature or another state administration to become incorporated. So you had to bring the charter to an official, basically, and say, I want to incorporate this company. And then they said yes or no. Then over the course of the 19th century, the European jurisdictions changed course and said, you can freely incorporate. You can choose for what purposes and where to incorporate, as long as you comply with certain minimum requirements of the law. So you have to have a place of registration, you have to have a name, you have to have a certain structure, so you have a board and you have shareholders. And so there are certain requirements in the law, but then you can just choose to set this up. And this led to an explosion of the corporate form, because many people took advantage of this, because it gives you certain privileges. One of the most important ones for shareholders is limited liability. So unlike the example of a small partnership that I gave you earlier, where our personal assets are in play when we do business, with the limited liability, our personal assets are not in play. We can invest in firms, they can create damages, they can pollute, they can do all kinds of things, but we will never, ever have to pay into a pool that would make the debtors whole again. If the corporation goes under, it goes under, and the shareholders walk away with the money that they have made earlier.
Well, it makes sense if I were in a position to have all that money and an interest and the ability to protect that I would inscribe such a process into the code, right? And that's kind of part of your argument, that this inscription of these protective schemes, or these, keeping us safe, so to say, always having our assets in safe harbors and protecting our own capital, our own property, our own wealth through these legal means, is part of the story of Western capitalism, global capitalism. Is that right?
Correct, exactly. So it started locally, domestically, if you want, and then you transpose the same mechanism to different types of assets, but also to different jurisdictions, and take advantage of the opportunity to even choose a different legal system, because it gives you more options to do this.
Fascinating. And how is this this panning out globally? So how do we get the global South, for lack of a better term now, how do we get former colonies, how do we get those countries into that story?
So one part of the story is that colonization is also a transposition of legal systems. So every colonizing power brought its law with it, and its commercial and civil codes as well. So when, first of all, when the English East Indian Company went to the subcontinent, of course, it also was allowed to rule people and to create rules. They used credits and indebted many people and used sort of common law principles. England also codified part of the English common law, which is non-codified, in order to transpose it to India. So there's an Indian Contract Act, which they wrote down what the principles of English contract law is and gave it to the Indians, right, under colonialism. Spain had, of course, colonized Latin America much earlier, but when the French Napoleon Civil Code was transposed to Spain and Portugal, then they transposed them to Latin America. French West Africa has a civil code, Egypt has a civil code, the Ottoman Empire, et cetera, et cetera. So you can look at the map of the colonial empires, and I can tell you which legal systems these countries have as a formal basis. During colonialism, very often the law applied only to the colonizers and some of the elites. They also brought the elites back to their home country to train them as lawyers. And then after colonialism, most countries basically made that law their national legal system for want of anything else, and because they already had been partly integrated into a capitalist system. So in that sense, they can play with the same elements if you want. But here again, of course, the same things are true. So they are more inclined, many former colonies, countries in the global South, emerging markets, etc. They often are pushed into accepting legal practices that benefit those, of course, who bring those legal practices. Open your borders to trade, not only to trade, but also to capital flows. Allow full repatriation of any revenues that are being made, maybe create free economic zones, which are special insulated places where we do not apply the general law of the land, including the administrative, regulatory or tax law, but we can only do our private law arrangements and then bring stuff back into the global market. So they have participated in this game, but also were forced to participate because the terms for global transactions and trade are set by those who have the better bargaining power, of course.
So we need to learn or accept that the legal foundation to have any kind of neo-colonial or financially colonialized agency by the Western countries, or by Wall Street, the city and other places of investing and reaping the benefits of these investments, are still leftovers from colonialism.
There are leftovers from colonialism, and they're also being recreated, and
reinstated,
they're being reinstated. I recently was on a Zoom call with a colleague from West Africa, and he had a quote from a French prime minister, I'm now blanking, but who basically said, we can let the colonies, the territorial control go, but we need monetary control.
It's, of course, much
monetary and financial control. So that's
allow our businesses to keep going there.
Correct.
Of course. And this is a practice I think we learned from, there's a book that now comes to mind by Susan Persson called The Guardians of, already in the mandate system in the League of Nations. You probably know this as well, where the Germans were very cleverly negotiating that for because of equal rights and protection of interests, and they gained a right to keep investing in their former colonies after the First World War. And so that businesses would still thrive, and they would, maybe this is one of the first stories of what you described, that, hey, it's actually not a bad idea to move out and save the money of running the administration, but and the military cost and all that, and keep the business going. Yes.
No, I think you can see this in not as you suggest. This is sort of an alternative, and maybe a cheaper alternative to straight colonization, right? Is economic and legal colonization, if you want to call it that.
Now that's all a little depressing, but in your new book, there seems to be an optimistic tone, because you say how to transform it, the law of capitalism and how to transform it. Now, how does this function? Could you say they're pretty powerful, I would say actors, these private lawyers, they're all well organized. They know there's the law has been written. So how are we going to change it?
So yeah, I have to make a confession here, maybe. So when I first read this book on the law of capitalism, I didn't have How to Transform It attached to it yet.
Okay.
And also, I had actually identified the core features of capitalism as a system that, in my mind, operate together to always reconstitute the system.
Yeah.
So the three features I identify is that we have a very strong empowerment of individual actors, including corporations. So it's not only about humans, but about corporations. We have a system that, yes, the state has centralized the means of coercion, but you have decentralized access to mobilize the means of coercion in order to protect your own interest, because you can use the law in a certain way, and you can also litigate strategically to get certain types of outcomes. And last but not least, we are tolerating and endorsing legal arbitrage, which is what I described before. You can pick and choose the law from different jurisdictions, you can take advantage of ambiguities in the law, etc., etc. So with these three mechanisms, I basically explained how even after major attempts to protect society from capitalism, maybe during the New Deal in the United States in the 1930s, or after World War II in many other jurisdictions as well, it always comes back. It always rears its head again. And typically it uses private law to get around the constraints that we might have imposed through public law. And so I basically said there's no exit, and presented this to my faculty, and even my colleagues at Columbia basically said you can't write a book like this. So
it's too depressing.
It's too depressing. So the question is, how would one? So I think it's maybe also too easy just to say you can't change. History changes all the time. You're a historian, you know, right? It changes in certain structures, but there's always change, and quite transformative change. We might not always like the direction, but it's happening. So the question is, can we also mobilize it in a different direction? So for me, then the key question was, how do legal systems change? So it's not just social change and social movements. There's a lot of literature about these kind of things, and but my fear is that they very often fizzle out and they don't reach into the the levels where the attorneys are creating the code of capital. You just don't get to that point. So you have to think about how a legal system would change and would also then stick to a particular path rather than revert back into capitalism. And I've come to the conclusion that this cannot be done by ingenious design, because these high-paid lawyers in these global law firms, they just know better, right? They're just really sophisticated. So any institutional design that you come up with can be repurposed in ways that we can't even imagine when we do this, which doesn't mean that we shouldn't try or, impose more taxes or have some more regulation, but we should also be aware of the fact that this can always be arbitraged around, at least to a certain extent.
Katharina, just to bracket here, when you say, well, this is is it a direct confrontation, or at least a pretty much, all those institutionalists, the John Rawlses of the world and the Habermases of the world, who would say, well, we have a transcendental institution and then, things will work out. You would say that doesn't work.
Well, I think I've become a skeptic of this, because I think we have to just understand how these institutions work dynamically and who has the power to change them. It goes back to what we said at the beginning. If some can change the rules of the game as the game is in motion, and it's not the ones who are democratically legitimated to do so, but those who have the power to do so, and have the right lawyers on their side, and do this in one area of the law, which, however, affects the others, and basically can get out and under from our democratic controls because they just take the legal system from a different jurisdiction and they're done. Then this is an illusion that you can create the system within which we can have derivative rules and that they comply with certain fundamental standards that we have applied. So nonetheless, I'm kind of also ending up by saying, we can have certain types of institutions that might be more conducive to a more equitable world, only with a shared normative foundation. So we can keep institutions the way that we want them to be, only as long as we can retain a particular commitment to institutions, which would basically say we will not enforce certain claims you might have arbitrage around the rules, and you might still be able to make a nice argument that it's still compliant with the black letter of the law if we can do X, Y, and Z, like, patent genes. You can patent genes because somehow we can make an argument. So, and what if we could just say no? What if we could? This is like a fundamental violation of our core principles. And so I'm basically saying we have to put private law onto a normative foundation akin to our original ideas about democracy and self-governance, putting the individuals at the center, and also then developing the tools for them to protect themselves from actors who are trying to infringe on their capabilities. I use the capabilities approach. But also enable them to use the law and other resources that society has to offer to live a decent life as well. So we need to reinstill normative.
Capabilities approach. So that sounds like Martha Nussbaum and Amartya Sen and this kind of idea of. But then would it need to, when we say, I mean, that sounds convincing, and I would definitely think that's a great way forward. How would we then? Isn't this a problem then that we need to define what that human norm is?
Yes and no. I think so. We do have to work in a similar direction, and I think the direction has to be to put the human and human interests at the center of our also private legal system. Yeah. That can take different forms in different cultures. So I think both Sen and Nussbaum were very mindful of not trying to impose a universalistic Western type of these are our human rights again. And I think I buy into that as well. At the same time, there's also been a dispute between Sen and Nussbaum in terms of saying, do we actually need like a catalog of capabilities? So Sen defined a capability as, every human having the right to live the life that she or he has reason to value. It's also a pretty high standard. You have to have reason to value. But the important aspect of the capabilities approach is it imposes an obligation on others. It's not only a negative right against the state, neither is it a positive claim against the state, you have to give me X, Y, and Z so I can live, but saying society has an obligation to ensure that everybody has the opportunity to live. Whether or not you have disabilities, whether you have you need certain things that have to be fulfilled. That claim, and this is important for me, that claim could also be made, let's say, against a foreign corporation. Right, because the schizophrenia in our system right now is we're always saying the state has to do something, but the state doesn't even have full control over what foreign corporations do, who operate under a different charter, a different legal system in our jurisdictions and transact in financial assets, which might blow up our financial system. You can try to regulate it, but they get around the regulations. So the idea that the state can do all that is kind of becoming increasingly an illusion. So the question is, can we basically sort of in some ways just take away the punch ball from the private actors who use the private law and basically say certain things that you're doing will no longer be enforced, and other things that you think you can get away with.
But who's saying that then? That would be the state who would need to say that.
The courts, of course, the courts to some extent. So yeah, so non-enforceability would be an act of courts. It could also be done through legislation. The problem, of course, is in our political system right now, the politics are so divided that having like a major legislation that would sort of reorder the system, I think, is also an illusion. Courts are, they're sort of sometimes work, sometimes don't work. It depends on where you are and who's sitting on the bench and what kind of case law they have developed. But I think there are some signs for hope in some kind of cases and jurisdictions that we've seen, and there are other signs where you would rather avoid going to the Supreme Court in the United States right now, for example, if you have an agenda like mine. So it depends. So you have to think about which actors that are sitting at critical nodes in the system are most likely to change or accept this notion. Because one of the reasons I've used the capabilities approach is it is fairly close to our ideas of having individual rights and sort of the original ideas, even original liberalism, right? It's close enough that many people would buy into it, but it has a little Trojan horse built into it because it's not only negative, it's actually positive. You have an obligation. And then we have to think about how to realize these obligations, these claims that you have to put me in a position so that I can do the things that I want to do and have also a right to do in my own life. And I think this would rule out many practices that have been very normalized today that corporations, including the tech companies, impose on us. I mean, when you think about how they organize their labor relations globally today, they should not be able to do so. And of course, then the questions you have to think about how you would operationalize all that, which I haven't spelled out in the book. I think that requires just much more careful analysis.
Could you maybe, for the non-legal ears and eyes of this, you mentioned negative and positive, and I know that this is a big discussion. We know much more about it, but so negative law and positive law. Would you
negative rights and sure.
Negative rights and positive rights. Positive rights are written down. Negative rights. No. What is?
No. It's a debate in constitutional law, and the question is always whether the civil and political rights that we create in our constitutions are negative rights, or whether constitutions should also grant positive rights. So negative right is I have a property right and the state cannot take it away from me.
Yes.
Or if it does, it has to pay compensation. I have the right to association. I have the right to free speech. So you can't impeach with my free speech right. These are classic negative rights. Positive rights is if you write into your constitution, you have a right to water, you have the right to housing, you have a right to work. And then the question is, how will the state fulfill these rights, right?
Yes.
And then there's something in between, like, the German constitution that has like a social principle built into the constitution, which can be used to interpret rights and how they're being realized in relationship to others. But the positive rights is basically you have a positive claim. You want something from the state. The negative is just stay out of my backyard. This is mine.
This is mine. And then what I meant with writing down is this is a dynamic function. You can claim more of these, the right to development has been claimed by, nations from Africa in the 70s and 80s. And so that will be positive rights.
You could say this. I mean, we associate rights mostly with individuals rather than with entire nations. But it's a similar. No, but you have a good point, because I think in the 1970s there was sort of this moment where we could have gone down a very different path than we have.
Yes,
we could have gone down a path to enable the newly independent states, the former colonies, to develop their own economic policies, to protect themselves from those that are being imposed from the global north, and yet still benefit from some resources that either the UN or the World Bank or the IMF might have made available to them. And to the contrary, we moved into a direction that sort of, I think, empowered these private actors with the legal tools that they, of course, knew better to use and had already fully implemented. Yeah.
There was this moment of the new economic international order.
Exactly.
And it's difficult to speak to the abbreviation, but this was the moment, and it faded out. It came, I guess, with the Brandt Commission as well, and there were a lot. So just for everybody this is the global context, and we're still trying to understand what went wrong. Some would say it's that was the neoliberalization also of these international, the UN commissions and these agencies and these platforms.
But I think this is also an important point, because it shows how important ideas are, right?
Thank you. Yes, I couldn't
an ideological shift has completely changed the system and closed opportunities that we might have had and created a different reality. But my hope is that with a new set of ideas, we could also sort of shift the way we do things. And if you look back to this period, you can also see this was not like one big stroke. So we just didn't change the entire system from one day to the next. But there was like this creeping new understanding of the world. Markets are efficient. The government is the problem. It's not the solution, as Reagan put it. And this became completely normalized.
Yes.
And if we just step back from this and say, what is this? What is this all about? For whom do we create these institutions, these arrangements? Who should flourish in the end, right? And what are the institutional structures that we need, and how do we have to imbue them with certain types of norms and ideas so that we can keep them on a particular path? That it's actually not about maximizing profits and creating trillionaires. It is actually about ensuring human flourishing more widely.
Beautiful. I couldn't agree more that there's a kind of a need for new humanism to be written into many of the normative foundations of our societies. I think this is all great, and we could go on into more detailed versions here, but I would like to add two more elements to the conversation, which is there could be more. Geopolitics could be one. Now the end of international waterways, because people have the idea, hey, I could tax you, I could take tolls because your ship. This would be the end of the international waterways. You're laughing. This seems to be a new trend now. But I would love to focus more on AI or digital technologies, because that's also your new project with the digital code, as one element of one field which is hugely influential and fundamental. How do we deal with this new need for a human basis of things when we talk about these new technologies? And the second part would be the second element, this awareness of the planetary problems of environmental issues and let's say the green transition.
Yeah.
Where do we start?
So with the digital code, because
okay.
I like to think about the digital code like I think about the legal code. In fact, in the Code of Capital, I basically said, think about the legal tools that the attorneys who code capital use. Think of it like you would think of a software code, or maybe the genetic code. That's basically it's the core material that carries the information with which sort of future decisions are made as well, right? Sort of it's basically, so that's what I thought about how to explain the legal coding. And obviously, if I already make the parallel to the software coding, there we are. I'm not a software coder, so I co-author this project with Pierre Georg, who is a physicist and an economist and deals with and can code digitally. So I can understand, through him what's going on. We put our heads together. And so the claim that we're making in this new project, which is called Coded Power, is that if you can control the formal means by which societies organize themselves, you have an enormous amount of power. And that's what I try to show in the Code of Capital. If powerful clients with the right lawyers on their side can code the way they organize their business organizations, their relationship with others, and impose their will on others, they're major rulers, right? And of course, the same is true with the digital code. So what has started in the 1990s with this more anarchist, experimental mode after the internet was open, of course, it came from the American military, so it always had a different structure too. But there was sort of this moment, again, like we talked about the 1970s. In the 1990s, there was this moment where people thought, this is, it opens so many new avenues, the way we could organize people's life, the kind of experimentation, the nerds who all of a sudden had their friends with whom they could do stuff on the internet. And then you see, like 20 years later, we have monopolized platforms controlled by absolute rulers. They're organized, their corporations, so they have full control. So Mark Zuckerberg has only a small economic stake in Meta, but he has full voting power. He has over 50% of the votes in his own name, right? So they structure these things already as autocrats. They use the legal tools to create autocracies, and then they basically rule over anybody who comes on their platform, because you can get onto the platform only if you click agree. And by clicking agree, you were signing lots of contracts that you never read, and that are kind of structured in a way that doesn't necessarily help you. It does help the other side, as you might imagine, including provisions that allow the other side to adapt the contract to future changes unilaterally without even requiring much of your own input. So you don't really know what kind of contractual obligations you have, but you have them. And so the digital coders, of course, use also the legal code to make sure that they can do with you what they're doing with you. And if you start trying to go to court, they might be able to defend themselves. Not always. Meta just lost a lawsuit, but in this way. So this is how I think about the digital code. And of course, the question then comes up is, well, how come they were able to get this control? What forces were at work? And how could one change this in the future?
What's the relation between the legal and the digital code?
So I think the digital coders think just like the economist, as we discussed earlier. They think they can do this without the law. This is a completely new world. They tell us they create like cryptocurrencies like Bitcoin and say, this is, this cannot be regulated. This is our own world. Just go away, state. This is, our own free world. And you have these libertarians like Peter Thiel and others who write manifestos to that extent. But of course, they also use the law to their own benefits. They all use corporations because they want to have limited liability. They structure their power through legal forms. But they also, and that's important to realize, they also use the digital code, and increasingly so. And I think one could think of the digital code as a possible alternative to the law. It's a way for organizing societies. It also has a lot of power built into it. It works differently. It's not the coercive powers of the state, but it's manipulation of behavior directly, I mean, or more indirectly if you want, but it's manipulation of behavior in ways that is more difficult to identify for ourselves, and therefore to also try to protect ourselves against, right? But it's a form of social ordering, and I think we have to understand it as such. And we have to respond to it as a power struggle. It's not just about privacy. It's not only about my own individual privacy rights. That's totally naive. But it's really a sort of a new form of social power that has emerged over the last 20 years or so.
Yes. I still struggle to understand quite why we were so enthusiastic about the whole thing in the night. Maybe it was together with the imagination of globalization being a force of good and freedom and prosperity for all, that we all believed, or many people believed. Maybe I was a little more skeptical, but not really. That the internet and all these possibilities, that would basically mean the democratization of everything. And
well, it's but it's interesting. In the 1990s, we also actually had control over our data because we all had our little personal computers with our floppy disks. Nobody could spy on us. We had actually physical control with that. I think the cloud changed a lot of that. And we also, in the 1990s, there was still this movement of, open source. So we deny the big companies the copyrights. We're just writing our own codes, and we do this together. We also have something like Wikipedia, right? That was created on the internet where people...
Comments.
Yeah. Well, what is interesting is then companies like Google come and they take Wikipedia's knowledge commons and commercialize it. So I've seen some studies where people have basically tried to do searches on Google. Now, it's, of course, we're now in the AI world, but a couple of years ago, do searches. If you exclude Wikipedia, most of the searches, become rather weak results. So they're free riding on people have come together and have done things like in the commons, but I think there have been others have taken the opportunity to then grab these assets, because there was, of course, again, the question, who has control over this? Who owns it? And if nobody owns it, can I not take it? And can I get away with it?
So you extract, so there's a new kind of resource, which is knowledge and data created by the commons is extracted. It's a new form of extractivism. It's a data extractivism.
Yes, exactly. But it's the same pattern that I've seen since the enclosure of land, or earlier, of course. But this is where I started in the Code of Capital. But it's the same pattern. It's whenever you have ambiguous allocations of rights, nobody knows what it is, and some people make a move and say, "But it's mine. I've put my labor into it. I've now built fences and hedges." And what they were smart already. 1986 in the US, a law was passed, the Computer Anti-Fraud Act, which said whenever data are put on a device, if somebody else tries to get into it, it's hacking, and it's punished like theft. So they basically created a new property right in data, but they gave it to those who control the device, not those who produce them. And we produce the data collectively all the time, but also really collectively. But those who then take them, who basically harvest the data and put them on the device, they have the property rights.
How do we change that? Well, that's a longer discussion. So, but maybe we can change it, maybe not. But it's definitely, the tensions are so stark between this naivete, which is still going on, because you're right, everybody just clicks agree, and by that you give away almost your rights to your own data.
Yes,
and they become collective good, or they become common, and then they become the property of somebody else, which is crazy. We're almost running out of time. Because I just see the time we're in almost for an hour now, Katharina. But I would love to talk about the green law, or the role of, or the priority that we can give to non-human actors, the environment, in capitalism, in reforming and transforming that political economy towards a more human future.
Yeah. So I think there has been a trend, and I think it's a trend that I can understand really well, to basically bestow rights on nature in one way or another, because in our world that is so deeply coded in law, and everything is about I have a right or you don't have a right, then you also have to create rights in order to defend anything. There's nothing you can defend without having a right, so you have to create it, but somebody has to defend it, because of course nature cannot defend itself. It needs human agents, as corporations do. So I think that's not a problem. You can create then human agencies that have to defend nature and have to defend nature's rights. But what it tells you basically is you're still entering a battle with our same basic principles, right? Nature might have some stronger rights than, I don't know, certain individuals, but you still have to enforce them. You have to still mobilize resources to enforce them. So in the current configuration of our global system, I think it's a symbolic step to give nature rights. And within this rights-based system where we basically says without rights, you have nothing, and we can do whatever with you, then it makes perfect sense to do so. But I'm not sure whether, given the power relations that we have also in this world, and again, where we have people who can change these rights and how they might be enforced, or prevent others from having access to the courts because they have to go to private arbitration, or so in that kind of world, just creating a new right for something like nature, I'm not sure will change the way in which the system operates. And so that's one thing. The other thing that I have issues with is this whole movement with ESG, environmental, social, and governance, in particular the E part. So capitalists will, of course, take advantage of every opportunity to make money. So there has been this relatively brief episode where environmental assets all of a sudden were the rage. Everybody was investing in them and they went up. Right? So if everybody has demand, then they go up. But if it turns out that brown assets like coal and oil and gas are still more, bring more returns, they drop them like a hot potato and go somewhere else, of course, right? So the idea again that we could do a green transition by using capitalist tools, like creating new types of assets and labeling them as green,
investment into the
that doesn't really comply with the logic of capitalism.
No,
because the investors don't care about these issues. The investors care about their returns. So unless you can ensure that the returns are sufficiently high for them, you won't make it stick. People will just move elsewhere where they can make greater returns as well. And at the same time, you're creating an entire industry of labelers, lawyers and accountants and other people who say this is green, this is not green. And then so what Adam Smith called the rentiers, right? So we have a new class of rentiers about these type of assets, but I'm not sure we have made any progress in actually bringing down emissions and saving the planet, which is our biggest commons, right? This is back to our original. This is our commons. There is no other. And the Elon Musks might shoot themselves into the moon as well, to space. That's fine with me, but for most of us, this is the only place we have.
That's right. This was so brilliant, Katharina. Let us stop here by just taking that in. And well, I do hear that there's a bit of that. The hopeful message is that we need to take more agency that could come from the courts to inscribe a more normative approach from the courts into the code, or so that the source of the code is normatively defined.
Correct. Yeah.
So that not everything can be extracted, and that could be maybe then transposed both on the, let's say, human-only system as well as the digitized systems of coding, and maybe even then also the environmental part of it. But that means that we need to come to some form of agreement of what that norm is. We have work to do.
I agree. Yeah, no, certainly we have work to do.
Okay, well, thank you so much for joining us. This was fascinating. Everybody click on her books, read her stuff, follow Katharina Pistor's work and the wonderful work also of your center at Columbia, which I've only scratched the surface of all the knowledge that is coming out there.
Thank you for listening to this episode of Planetary Choices. This podcast is produced by the Center for New Critical Politics and Governance at Aarhus University. Visit our website and join us for another episode of Planetary Choices.
So thank you so much for joining us, Katharina.
And thank you. It was a wonderful conversation. Have a great day.
You too.